Today we are going to be looking at the area of vitiating factors, and in particular the areas of mistake and misrepresentation. As we have seen, for a contract to come into existence, it is necessary to have a meeting of the minds between the two parties. This meeting of the minds is not considered to occur in the following situations. Mistake. This is where the parties entered into a contract on the basis of an error. For example, X agrees to buy Y's horse, but unknown to either X or Y, the horse is dead. The meeting of the minds is also not considered to occur in cases of misrepresentation. This is where X induces Y into an agreement on the basis of a statement that is untrue. For example, X might tell Y that the horse he is selling him is only 5 years old, when in fact the horse is 10 years old. The meeting of the minds is also not considered to occur in cases of undue influence, duress, or unconscionability. Undue influence is said to occur where one of the parties to the contract induces the other to enter the agreement by exercising an undue influence resulting from an imbalance in the relationship between the parties. Certain types of relationships, for example doctor-patient relationships, are considered to create a presumption of undue influence. Duress occurs where one of the parties robs the other of his free choice to enter into a contract. The obvious example is if X holds a gun to Y's head and forces him to sign a contract. Unconscionability occurs where someone in a superior negotiating position imposes incredibly unfair transactional conditions on the other party. For example, X finds Y lost in the desert and they reach an agreement whereby X gives Y a drink of water in return for 100,000 euros. Now let's look more closely at the area of mistake. The presence of a misunderstanding or mistake on the part of the parties may lead the courts to find that there has been no meeting of minds between the parties. However, for a mistake to prevent a contract coming into existence, the mistake must go right to the heart of the contract. If the mistake concerns a trivial question of minor importance, then the contract will continue in force. In the same way, a mistake will not work to invalidate a contract if the mistake concerns an error of judgment. If X sells his horse to Y and Y, mistakenly thinking that it is a more valuable horse, pays above the market rate for the horse, such a mistake will not invalidate the contract. It is important to appreciate what type of mistake has occurred, i.e. whether it was a case of common, unilateral, or mutual mistake. If it is a case of common mistake, i.e. both X and Y both mistakenly believe the horse to be alive when it is in fact dead, then clearly the contract will not be enforceable. If only one party has made a mistake, i.e. unilateral mistake, then the mistake will not be considered operative, i.e. will not operate to invalidate the contract unless it was induced by fraud. If it is a case of mutual mistake, i.e. the parties were at cross purposes with each believing that they were buying and selling a different horse, then the agreement will not be enforceable as long as the respective errors were reasonable. Now let's look at the area of misrepresentation. There are 3 types of misrepresentation: fraudulent misrepresentation, innocent misrepresentation, and negligent misrepresentation. Let's look first at fraudulent misrepresentation. Fraudulent misrepresentation is where one party, X, misrepresents a material fact, i.e. does not tell the truth about a material fact, to the other contracting party, Y. For a finding of fraudulent misrepresentation, the plaintiff must demonstrate before the court that the misrepresentation 1. concerned a material fact, 2. was made knowingly or fraudulently, 3. with the intent to defraud, 4. was relied on by the plaintiff when entering the contract, and 5. caused loss to the plaintiff. Let's look at the case of Redgrave and Hurd. In this case, Y contracted to buy X's house. The contract to buy the house was part of a larger transaction whereby Y was going to invest in X's legal practice. In this regard, X misrepresented to Y that the practice was bringing in revenue of £400 and gave him documentation which he said proved this. In fact, the papers, had Y read them, would have revealed that X's practice was virtually worthless. When Y later discovered this, he informed X he was not going ahead with the contract to buy the house. However, the contract of sale for the house was signed, and X sued for specific performance of Y's promise to buy the house. Y claimed a right to rescind the contract on the grounds of fraudulent misrepresentation, i.e., that X fraudulently misrepresented the value of the legal practice. In the opinion of the court, it was irrelevant that Y failed to read the papers X had given him. X made a fraudulent misrepresentation to Y, and Y relied on the misrepresentation when entering into the contract to buy the house, and thus Y could rescind the contract. However, it is important to note that to succeed in an action for fraudulent misrepresentation, the contested representation must concern a factual issue and not be an opinion. In Bissett and Wilkinson, X was selling his farm to Y. During the negotiations, X told Y that the farm could accommodate up to 2,000 sheep. At the time of making the representation, the farm was not used for sheep farming, and Y knew that X had no expertise in this area. After buying the farm, Y realized that the farm could not support 2,000 sheep and brought an action to rescind the contract on the grounds that X had fraudulently misrepresented its capacity. The court held that Y's action should fail, as the court considered that X's statement was only an opinion as to the capacity of the farm and not a statement of fact. For the court, Y should have realized that X, who had no sheep farming experience, was only giving an opinion. Once fraudulent misrepresentation is established, it gives the deceived party the right to rescind the contract and to seek damages in the amount of his or her losses. Alternatively, a party can choose to affirm the contract but seek damages for the losses linked to the misrepresentation. Moreover, the qualification of a representation as fraudulent can have serious financial consequences, as it will probably prevent the other party responsible for the misrepresentation being able to rely on any exclusion or limitation of liability included in the contract document. This is perfectly logical, as at common law it is not possible to exclude liability for fraud. In B-Sky B Limited and HB Enterprise Services UK Limited, HB, or Hewlett-Packard, a system supplier, fraudulently misrepresented in its pre-contract sales presentation to B-Sky B the ability of its customer support relations management system. In the agreement that was subsequently entered into between the parties on the basis of the sales presentation, HB's liability was capped or limited to £30 million. The system later failed to function in line with HB's claims, and HP sought to rely on the £30 million limitation of liability. However, the court ignored the £30 or million pound cap, and damages of £300 million were awarded. In its decision, the court confirmed that in cases of fraudulent misrepresentation, it is not possible to benefit from a limit on liability in the contract entered into as a result of the misrepresentation. Now let's look at the area of innocent misrepresentation. Innocent misrepresentation differs from fraudulent misrepresentation, as the party making the misrepresentation does not know that it is false and does not make the statement intending to defraud the other party. In other words, the misrepresentation is made innocently. In the US, innocent misrepresentation does not normally give a right to damages, and normally the only remedy available to the victim is rescission. However, in the UK, there is a limited right to direct damages in the cases of innocent misrepresentation. Now let's look at the area of negligent misrepresentation. Up until the 1960s, there was only two actionable categories of misrepresentation: innocent misrepresentation and fraudulent misrepresentation. However, in 1963, the common law courts recognized a new form of misrepresentation under the heading of tort law, namely negligent misrepresentation. Negligent misrepresentation can be defined as a non-true statement that is made without reasonable grounds for believing in its truth. In the UK, an action in negligent misrepresentation is now available under Section 2 of the 1967 Misrepresentation Act. According to Section 2.1, the burden of proof is on the party making the representation to show that he had reasonable grounds for believing the statement to be true. The same remedies available for fraudulent misrepresentation are available for negligent misrepresentation, namely rescission and/or damages, although any award of damages will be made pursuant to tort law damage assessment rules rather than those applicable to the area of contract law, as is the case in fraudulent misrepresentation. We hope you enjoyed this introduction to the areas of mistake and misrepresentation.